Hello friends, in the series on the income tax cases, today we will discuss a very important issue in regard to the assessment of the assessee in case of such matters. The assessment of any assessee in the case of such matters have been ever a matter of litigation, whether it is the assessment under block assessment, whether it is the assessment under section 153A, 153C, or whether it is a assessment under section 148 after 1st April 2021 searches. The issue before the Chennai ITAT in the present case was that whether the statement which is recorded during the search proceedings of any assessee can take the form of incriminating material without having the other corroborative evidence, or in other words, whether the assessment of any non-searched assessee can be done under section 153A on the basis of incriminating material which is found in the search of other assessee. Both the issues have been taken up by Chennai ITAT B bench in the case of Deputy Commissioner of Income Tax versus BSR Builders, Engineers and Contractors, and this case is reported in 121 ITR Tribunal at page number 626, and the date of the judgment is 27th March 2024. The facts of the case are very interesting. In the present case, the assessee is a builder. The assessee is making various projects by taking the land of some other assessee and then constructing building on that, whether it is residential or commercial. And it was a determined fact in the present case, the assessee was following the project completion method for its accounting purposes. In the present case, there was a search on two persons, that is M and R, and in the search of those assessees, that is M and R, some unaccounted money, some incriminating evidence including loose sheets containing details of cash payments made by the assessees M and R to the assessee in hand. On the basis of that, a search was also conducted on the assessee on the same date. The statement of the assessee was recorded. In that statement, assessee accepted some undisclosed income, and then the show cause notice was issued to the assessee for completing the assessment under section 153A to establish the credit worthiness and the source of the cash which has been received by the assessee. The assessee explained that whatever the cash has been received, that is the cash which has been received by the assessee as an advance, and since the assessee is following the project completion method, it will be shown as income when the project will be completed. The assessing officer didn't accepted the submissions of the assessee and made the additions. When the matter was before the learned CIT appeal, the assessee first time raised the ground that in the present case, the assessment of the assessee has been completed under section 153A on the basis of the evidences received or the incriminating material received on the search of some other assessees, that is M and R. So my assessment should have been completed not in section 153A but under section 153C. The assessee raised this legal ground first time before the CIT appeal. When this matter was heard by the CIT appeal, the CIT appeal allowed the appeal of the assessee by saying that in the present case, the assessment done on the basis of statement of the assessee is not accepted because it is a settled law that the statement is not an incriminating material, and since the additions have been made on the basis of the incriminating material found in the search of the other assessee, so the assessment of the assessee should have been completed under section 153C and not under section 153A by recording a separate satisfaction note. When the revenue filed the appeal against this order in the tribunal upheld the order of the CIT appeal by saying that in the present case, the assessing officer has wrongly invoked section 153A and the assessment under section 153A is bad in law, because in the present case, whatever the additions have been made, that is on the basis of the incriminating material which have been found in the search of other assessees, that is M and R. The tribunal upheld the order of the CIT appeal to that extent also that the statement recorded in a such proceedings does not constitute the incriminating material. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus BSR Engineers and Contractors, and this case is reported in 121 ITR Tribunal at page number 626, and the date of the judgment is 27th March 2024. Thank you, friends.